afternoon. This is Robert Chisholm from Chisholm, and Kilpatrick. Joining me today is Sara Papantonio from the law firm of Levin, Papantonio. In this video, we're going to be answering the question, can I pursue both a VA disabilities claim and a Camp Lejeune Justice Act claim? Sara, can you give us sort of an overview of the Camp Lejeune claims?
Sure. As many of you viewers have seen and heard about the Camp Lejeune water contamination, you know, this is one of the largest water contaminations in American history. And you are eligible as a plaintiff in this case if you were at Camp Lejeune between 1953 and 1987 and suffered a unique type of injury as a result of being stationed at Camp Lejeune. Now, this does not only apply to you as a veteran, it also applies to family members that were there with you or loved ones who had passed away. Now, the important thing to remember about these Camp Lejeune claims is that you only have 2 years to file, right? So we only have until August of 2024 to bring these actions against the government. But a lot of questions surround the Camp Lejeune Justice Act, and that's why I'm so grateful to be here with you today, Robert. The biggest question that we get is the Camp Lejeune water contamination litigation the same as pursuing VA disability benefits? And the answer is no. These two things are completely separate. So the VA benefits are completely separate than any claims you make against the government on behalf of the Camp Lejeune Justice Act. So that's the important first thing. The next question that comes from that is, well, which angle should I take? Should I go the VA route or should I go the Camp Lejeune claims route? And my answer every time is you should do both. Right? You should pursue your VA disability benefits, and you should also pursue these claims as a victim of the Camp Lejeune water crisis. Because what we know is that this litigation is going to take a long time, just like pursuing VA disability benefits takes a long time. So it's best to put your eggs in both buckets and pursue both routes. That way we can maximize any potential recovery that you're entitled to in these cases.
I think it's really important to emphasize that anyone who's considering filing a claim should file in both arenas, so to speak. So you should file your VA claim for disability benefits based on Camp Lejeune, and you should also file the administrative claim under the Justice Act. And there's nothing wrong, legally speaking, with filing both at the same time. I think that's really important to emphasize. Now,
absolutely. Let me just add to that. Sorry, because I didn't mention this. Is if you file a claim with Camp Lejeune under the Camp Lejeune Justice Act, it will have no bearing on your VA disability percentage, right? Your percentage disability. So that's an important thing to highlight. I'm glad you brought that up, Robert. Thanks.
So then the other question that comes up is, can I file these claims on my own? And the short answer is you can file both a Camp Lejeune Justice Act claim on your own and a VA benefits claim on your own, but we strongly advise against it. Our firm has decades of experience handling veterans' claims before the VA, the board, and the Court of Appeals for Veterans Claim. Levin Papantonio is a leader in the mass torts arena, and together we can help you pursue your benefits, understand any potential offsets that arise, and ensure your maximum recovery under both acts. Again, we encourage veterans and their families to pursue both of these options and determine which is the best for them ultimately. So veterans and families can fill out the form to find out if they are eligible. For more information regarding offsets, check out our previous video. Also, stay tuned for future videos regarding this lawsuit and VA benefits. As always, we are happy to answer any questions you may have. Thanks for watching, and Sara, thank you for joining us today.
Thanks for having me.